Good morning, everyone. I am Judge Jackie Powell, and we're in first appearance court this morning. In the courtroom today, I have representatives from the State Attorney's Office, Mr. Eric Linder, Ms. Elizabeth Friedman. From the Public Defender's Office, I have Mr. Brian Reedy. We also have pretrial supervision services representative. We have confinement status representative, and we also have the clerk of court. Today is first appearance. That means today's not your trial. Today's not even your arraignment for you to enter a guilty or not guilty plea. Today is the day when I call your name and you come up, I'm going to tell you what you've been charged with, and I will make a determination as to whether probable cause exists to detain you, and if so, what kind of release conditions to put you on. All right? Everything in this courtroom is being recorded, so I would advise you not to speak about your case, especially if you plan to take this case to trial, because everything you say can and will be used against you. For those of you at the main jail, there's an attorney from the Public Defender's Office. If you are represented by the Public Defender's Office, you may want to speak with that attorney before you say anything on the record. For those of you who have private attorney, your private attorney may show up in the courtroom this morning, or if there is an extenuating need, then I may have to place a phone call to that private attorney. But in either case, everything is being recorded, and so I'm asking you, not to say anything about your case on the record unless you know exactly what you're doing. When I call you up, I'm just going to ask you to come up to the podium, and I will tell you what you've been charged with, and we will start this morning with Bruce David Vanderwood. Good morning, sir. You're before the court today for an out-of-state hold, and so you will be going before an extradition judge shortly, okay? All right, good luck, sir. Candace Foster.
Ms. Foster is here present, Judge Edmond. Come on up, ma'am.
Good morning, Ms. Foster. You're before the court today for a misdemeanor capias on a prostitution charge. The court does find probable cause. What does Ms. Foster wish to do today?
Judge, after speaking with Ms. Foster, she wishes for me to ask the court if you would consider resolving this matter today.
Offer from the state be time served, Your Honor.
Okay, Ms. Foster, if you wish to resolve your case today, it's an adjudication and time served will be your sentence. Do you wish to resolve your case that way?
Yes. Yes, Your Honor.
Ma'am, please raise your right hand. Do you swear or affirm to tell the truth? Do you swear or affirm to tell the truth?
You just cut
It
your
cut out
voice.
a second.
Okay, we'll try it again. Can you hear me?
Yes, I can now.
Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Please state your name for the record.
Candace Foster.
And Ms. Foster, do you understand the proceedings that you're in today?
Yes, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Do you understand that by resolving your case today, that you're giving up your right to go to a trial?
Yes, ma'am.
Is that what you wish to do?
Yes, ma'am.
Ms. Foster, has any promise made to you to resolve your case other than the proposed sentence?
No, ma'am.
Have you ever been treated for mental or emotional illness?
Yes.
Are you currently under the supervision of a doctor?
Not here. I've been in prison for the last 4 years, so I've been getting medical treatment there.
Okay, but do you understand everything that is going on here today?
Yes, ma'am.
Do you understand that if you're not a U.S. citizen, that you could face deportation charges?
Yes, ma'am.
Okay. Then, Ms. Foster, what plea do you wish to enter today?
No contest.
Then I accept your no contest plea. I find that it is freely and voluntarily given. I sentence you to adjudication and time served. Ma'am, I'll give you 6 months to pay your court costs.
Okay.
Good luck. Jacqueline Bendel.
North Broward.
Ms. Bendel is in North Broward, Your Honor.
Thank you.
She'd
Good
like to
morning.
resolve this matter today if possible.
Okay, good morning, Ms. Bendel. You're before the court for 3 counts of misdemeanor capias. The court does find probable cause. Your attorney tells me that you wish to resolve your case today. Is that correct?
Yes, ma'am.
These are, well, two of these, Ms. Bendel, two of these counts are municipal ordinance cases. Your state case, the public defender's office tells me you wish to resolve, but you don't have an attorney on the municipal ordinance counts. Do you still wish to resolve your case, or do you wish to wait for an attorney on those 2 counts?
I want to resolve this.
Okay. As to the state what offer do you have?
Your Honor, the offer being adjudication, time served, no return to 5845 Hollywood Boulevard. Your Honor, just advise, just to let the court know, if you could advise her, she can't go back there. Apparently, she's been trespassed in this location on multiple occasions.
What is the address that she's no return, 5845?
Hollywood Boulevard in Hollywood.
Yes, Your Honor. Ms. Bandel and I discussed the importance of her not returning to this location. She indicated to me that she will not.
Okay. Ms. Bendel, if you wish to resolve your case, the sentence will be adjudication time served on all 3 counts.
Okay.
Do you wish to resolve your case in that manner?
Yes, ma'am.
All right, can you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
You can put your hand down.
Thank you.
Please state your full name for the record.
Jacqueline Bendel.
And Ms. Bendel, do you understand the proceedings that you're in today?
Yes.
Do you need more time to speak with your attorney?
No, ma'am.
Do you understand that by taking a plea today, you're giving up your right to go to trial?
Yes, ma'am.
Do you understand that if you are not a U.S. citizen, you could face deportation by pleading out these cases?
Yes, ma'am.
Ms. Bendel, have you ever been treated for emotional or mental illness?
Yes.
Are you under any treatment of a doctor now?
No.
Is there
No.
anything that is affecting your decision-making today?
No.
Okay. So what plea do you wish to enter as to these 3 counts? Guilty or no contest?
No contest.
Okay, then I accept your no contest plea. I find that it is freely and voluntarily given. I sentence you to an adjudication and time served on all 3 counts. But also, I want to implore you not to return. It's an order to 5845 Hollywood Boulevard. Otherwise, you'll be arrested if you're found there, okay?
Okay.
Ma'am.
Does that mean I get released today?
Yes, ma'am, unless there is something else holding you in custody that I don't know about.
No.
No, I didn't
there's
see
not.
anything, Judge. Good luck. Good luck, Ms. Bendel.
I'll give you
Thank
6
you.
months to pay your court costs. Good luck.
Okay.
Brianna Price.
Paul Ryan.
Good morning, Miss Price.
Good morning, Your Honor.
You're before the court today for 1 count of possession of cannabis, 20 grams or less, and you're also on violation of probation. So the court does find probable cause, and as to count 1, your bond is $100. Count 2, you're on a no bond hold. You will be going to your felony. Is this out of
Your Honor,
Broward?
Ms. Price is on probation out of Brevard County.
Out of Brevard.
I'd ask the court to consider releasing her on her own recognizance on count 1 so that Brevard County can come and get her.
Okay, then I'll, ROR you on count one, and, I guess, you'll be before a judge soon. Good
Okay, Your
luck,
Honor.
good luck.
Thank you very much.
Good luck,
Carrie,
Ms. Price.
Carrie Ann Van Dyne.
North Broward.
Good morning, Ms. Van Dyne.
Good morning.
You're before the court today for one count of possession of heroin, and the court does find probable cause.
Judge, I'm going to ask the court to consider pretrial release for Ms. Van Dyne. I don't know if the state has an objection. Eric, Eric, did you hear what I said? No. Oh, I'm sorry. Carrie Van Dyne, I'm asking the court for pretrial release.
Just one moment, Your Honor. I have no objection to pretrial, Judge.
Okay, then, Ms. Van Dyne, I will release you to pretrial supervision, with random testing.
Okay.
Okay, good luck.
Is that,
They should give you a map right now, Ms. Van Dyne. It'll show you where to go. You need to be there within 24 hours of your release from jail.
thank you so much. Thank you.
All
Good luck.
right. Manushka Joseph.
She's approaching, Judge. She's here at Maine.
Good morning, Miss Joseph.
Good morning, ma'am.
Ma'am, you're before the court for one count of neglect, child without great bodily harm. The court does find probable cause. I will, release, Mr. Joseph to, standard pretrial supervision. Good luck, ma'am. Yorlina Rivas.
Ms. Rivas is here, Judge. She informed us she has private counsel.
I spoke with her attorney, Your Honor, and, well, he's not her attorney, is the bottom line. He does not represent her, so she's gonna have to go with the public defender's office.
Who was that attorney?
You know, I don't know his last name. I just got his name Richard, and I didn't really have a chance to talk to him because court had already started, so
Okay.
I didn't get his last name.
Ms. Rivas, good morning. You've indicated that you have a private attorney, but that attorney is not representing you. So do you need more time to speak with the attorney from the public defender's office?
Do you want the public defender?
For now, yes.
All right, one moment, Judge.
Okay. You want me to recall it, Mr. Romero, or?
One quick second.
Okay.
Judge, I've had a chance to speak with Ms. Rivas. I'm ready to proceed.
Okay, Ms. Rivas, you're before the court this morning for possession of a controlled substance without prescription. And then there is, a seatbelt violation, which is not from magistrate. The court does find probable cause, and, what does the,
Judge,
do you wish to
she
be
gave
heard
the
as?
phone number.
I'm sorry.
She gave me the phone number of a friend. I intend on calling him right after court to post their bond.
Okay, the bond is $1,000. The second count is not for magistrate. Good luck. Tiffany Leah Mock. Where's, Miss Mock?
Yes.
Where is she? North
I'm right
Broward?
here.
North Broward.
Okay.
Good morning, Ms. Mock. You're before the court today for touch and strike battery and criminal mischief. The court does find probable cause.
Your Honor, I did not see an amount listed as far as the damage is concerned relating to count 2, criminal mischief over $1,000.
Your Honor, that's fine. I have no objection to the court finding probable cause for misdemeanor criminal mischief. That being said, I am gonna be asking for $1,000 bond on the battery, as that is the standard bond. I'm showing Ms. Mock in 2017 was convicted of battery on a law enforcement officer and grand theft with a violation of probation. Possession of cocaine, 2017, resisting without violence, 2017. I would also note that the arresting officer reviewed surveillance video which corroborated the allegations in this matter.
Okay, so we're doing criminal mischief. Wait,
I'd ask you to ROR her on count 2, Judge, and set a $500 bond on count 1. Based on my conversations with Ms. Mock, who has lived here all of her life, and has lived at the same location since she was 8 years old with her parents. From what she tells me, if I call her mom, which I will do, they might be able to make a $500 bond. I don't think they're going to be able to make much more than that, however.
all right. At this time, the court does find probable cause, and I will impose a bond of $500 on count 1 and ROR Ms. Mock on count 2. In the meantime, Ms. Mock, you shall have no contact with Ruiz Lopez. Do you understand that? Okay.
Yes.
Good luck, ma'am.
All right. Thank you.
Good luck.
We have some persons sitting in the courtroom. Deputy, if you can just let me know who they're here for. Okay. All right, thank you. And we'll go to Jennifer Jones.
Full run, Your Honor.
Good morning, Ms. Jones.
Hi.
You're before the court today for 1 count of possession of cocaine, 2, drug paraphernalia, 2 and 3 are, possession of drug paraphernalia. Count 4 is, felony violation of, pretrial.
Judge, just for the record.
Yes.
Sorry, just for the record, count 4 was no info. So if she's able to post bond, she can bond.
Okay. And then so count 4 is no info.
Even though it's not the magistrate.
Right.
Just wanna let her know she can bond.
Okay, and count 5 is a misdemeanor capias. The court does find probable cause.
Ms. Jones indicated to me that she can bond out, Judge, and I would ask the court to leave the bonds in place.
So the bond on count 1 is $1,000. 2 and 3 is not for 2 and 3, I will not impose a bond. 4 is not for magistrate, and 5, the bond is $500. Good luck. Destiny Summer Barnes.
Medical reset, Your Honor.
Medical reset. Elmer Rivera.
Come on up, sir. Judge, we're gonna need a Spanish interpreter for Mr. Rivera.
Okay, then we'll have to recall once the Spanish interpreter gets here. Thank you. Manuel Perez.
Mr. Perez is here, present, Judge, at me.
Mr. Perez, you're before the court this morning for an accident, unattended vehicle without leaving your ID. The court does find probable cause. Your bond is $25, sir. I'll leave that in place.
Thank you, Judge.
Good luck. Eduardo Moreno.
Mr. Moreno is here present, Judge at main.
Mr. Moreno, good morning. You're before the court today for count one. There's an out-of-county hold on a civil writ, and then count two is a misdemeanor capias. The court does find probable cause. There's nothing that I can do with count one. As to count two,
Judge, nothing for the defense.
then the bond is at $250. Good luck. My notes also indicate that he should be in court tomorrow at 9 a.m. Scott Brian Clifton.
Mr. Clifton is here present, Judge.
Mr. Clifton, you're before the court today for count one on natural and lascivious act, and count two is driving while license suspended, first offense. The court does find probable cause, and as to count one, I'll impose a bond of $1,000. And the bond of $100 will remain on the second count. Good luck, sir.
Judge, I'm going to be first asking Mr. Clifton's request. I do understand that both offenses are misdemeanor offenses, Judge. I'm going to be asking the court if the court would consider resolving this matter today.
Okay, does the state have an offer for?
One moment, Judge, I'd have to check his driving record. Yeah, but it's not charged with prostitution, so with that, do you know if the fine would come with that? Actually, Judge, I don't have an offer, Your Honor. I'm showing in 1997, Mr. Clifton's driving privileges were permanently revoked by the state of Florida as a result of multiple DUIs. It's okay, don't worry.
What year was that? 1995?
1997, but just so the court's aware, he's had other DWSs since then. Yeah. So,
Judge, I did advise him one of the possible consequences is having three of these offenses within 5 years time span. There are consequences as far as having your driving privileges suspended for 5 years. He is aware of that, Judge. He told me he's had none within the last 5 except for this one. So that's why he wishes for me to ask the court if he would consider resolving this matter today.
Yes, I believe the indication from the state has been permanently revoked since 1997. So, if Mr. Clifton wishes to resolve his case, the offer from the court will be adjudication 10 days in the Broward County Jail.
Respectfully, Judge, Mr. Clifton is going to say no to the court's offer.
Okay.
He's been bond out, Judge.
Okay, good luck. Clayton Kaid McFarland.
Mr. McFarland's approaching, Judge. Come on up, sir.
Mr. McFarland, you're before the court for count one, possession of cannabis 20 grams or less. The court does find probable cause.
Nothing to add from the
Your
defense,
bond is
Judge.
$100, sir. Good luck. Alexis Charles Campbell.
Mr. Campbell is here present, Judge. Come on up, sir.
Mr. Campbell, you're before the court this morning for failure to register motor vehicle, driving while license suspended, first offense. There's 3, 4, and 5 are misdemeanor capious, and 6 is an expired driving license over 6 months. The court does find probable cause, and as to count,
Judge, I'm
yes.
sorry. Mr. Campbell wishes for me to ask the court if you would consider resolving these matters. I believe the capiouses are in reference to a 2013 offense. Having said that, Mr. Campbell would like to resolve this matter today.
All right, there's a driving while license suspended to 2013. There's a engaging in business contract without license from 2013.
And Your Honor, the offer from the state on 1, 3, 4, 5, and 6 would be withholds and an adjudication time served on 2. But admittedly, I don't have his driving record in front of me. I don't know if pleading out 2 DWSs will have,
1, 3, 4, 5, and 6 withholding court costs,
that would be the offer, yes.
and 2 is adjudication and time served.
Yes, ma'am.
Madam Clerk, do you have Mr. Campbell's driving record? Thank you. Looks like 2014, there was a driving while license suspended that he resolved in 2014. 2009. And before that was 2000, then 1999.
So based on 2014, it looks like he could potentially receive a 5-year visualization.
So the last one is the 2014, so there's a potential 5-year, 2014. Right.
Judge, I did speak to Mr. Campbell as far as the court's concerns. And I did advise him if he had 3 within 5, but he still wishes to resolve this matter today
Okay,
and accept the state's offer.
Mr. Campbell, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down, sir. Please state your full name for the record.
Alexis Charles Campbell.
Mr. Campbell, do you understand the proceedings that you're in today?
Yes.
Do you need more time to speak with your attorney?
No.
Is anyone forcing you to resolve your case today?
No, ma'am.
Do you understand that you do have the right to go to trial and that resolving your case today means that you're giving up that right?
Yes, ma'am.
Have you ever been treated for emotional or mental illness?
No, ma'am.
Do you understand that if you're not a U.S. citizen, that by taking a plea, you could be subjected to deportation proceedings?
Yes, ma'am.
All right. Mr. Campbell, what plea do you wish to enter at this time? Guilty or no contest?
What should I say? No contest. No contest. No contest.
Okay, Mr. Campbell, I accept your no contest plea. I find that it's freely and voluntarily given. As to counts 1, 3, 4, 5, and 6, your sentence will be a withhold adjudication and court costs. As to count 2, it'll be adjudication and court costs. Sir, I will give you 6 months to pay your court costs. Good luck. Dean, Annabelle Tadeo Dean.
He is approaching, Judge. He's here at me.
Good morning, Mr. Dean.
Good morning.
Sir, you're before the court this morning on 3 counts of possession of drug paraphernalia, and count 4 is a possession of cannabis 20 grams or less. The court does find probable cause. I will not impose a bond on the paraphernalia. And
Judge.
yes,
My understanding is, when he was arrested, he didn't have his phone with him, and his father doesn't know he's here, so he has really no one to try and contact to post his bond. We're gonna be asking if the state has an objection to have him release ROR on the cannabis offense.
That's fine, Judge.
okay, then as to count 4, he'll be ROR. Good luck, sir.
Thank you, Judge.
Henry Douglas Lucero.
Mr. Lucero, come on up, please.
Mr. Lucero, you're before the court this morning, 1 count of operating without a valid driver's license, 2, presenting a non-current proof of insurance, and 3 is a traffic capias. The court does find probable cause. What does Mr. Lucero wish to do?
Judge, he's gonna post his bond. I'm gonna contact his wife after court to, have her post his bond.
Okay, the bond on 1 is $100, and then on 3, $250, and not impose a bond on 2. Good luck, sir. Curtis Hubbard. Curtis Lee Hubbard.
His bond was posted, Judge.
Good morning, Mr. Hubbard. You're before the court today for possession of cannabis 20 grams or less, driving while license suspended, expired tag, failure to wear seatbelt, unsecured tag. The court does find probable cause, and Mr. Hubbard, I've been informed that your bond has been posted. Good luck, sir. Robert Bass.
Mr. Bass, come on up, please. He's approaching, Judge.
Mr. Bass, you're before the court today for trespassing. The court does find probable cause. What does Mr. Bass wish to do?
He wishes to resolve this case, Judge.
Your Honor, I don't have an offer. Mr. Bass appeared before you on Tuesday. You gave him a stern warning not to go back to this post office. Again, I believe Judge Lerner Wren it would be appropriate to transfer to Judge Lerner Wren.
All right, the court will sign an order to send this matter to Judge Lerner Wren. Mr. Bass's bond is $25, and I'll sign that order. Daryl Shane Hughes. Daryl Hughes? Okay,
Medical reset.
thank you. And how about David Mazzola?
Right here.
Dino Mazzola.
Judge, it's up for release. Yesterday he received pretrial electronic monitor
On which matter?
on everything.
On this, even on this case that is,
Yes, I believe he went maybe in front of murder.
it looks like yesterday no, today's the 31st.
They put him on pretrial almost everything.
All right, so, Mr. Mazzola, I do find probable cause, and my understanding is you were in court yesterday, is that correct?
Yes, Your Honor.
And that you were placed on pretrial release with a monitor?
Yes, Your Honor.
Okay, then that's in place. Good luck, sir.
Thank you.
David Gray. David Gray,
Medical reset.
okay. Shane Dukes.
Medical reset?
Ronald Edward Myers.
Conti, Your Honor. Morning, Your Honor.
Good morning, Mr. Myers. Mr. Myers was before me recently. Is this another charge?
It's another charge, definitely.
Mr. Myers, you're before the court today for grand theft. Your bond is $1,000. Good luck, sir.
Thank you.
Okay. All right, Damian Cachio Burton.
He's here, present, Judge Amin?
So was Mr. Burton, before this court recently? Because count one is not in this PC.
Correct.
Okay, all right. So, Mr. Burton, today you're before the court for, we've already addressed count one, which was the false imprisonment. Count two is a possession with intent to sell, deliver alprazolam, possession of heroin, possession of alprazolam, possession of bunylephrine, and 5 is drug paraphernalia. The bonds will remain in place as stated, $1,000 on count 2, 1,000 on 3, 1,000 on 4, 1,000 on 5, and 100 on 6. Good luck, sir. James Brinkley.
Judge, he's here present, and at this time, we're gonna be waiving formal reading, of the charges, Judge. Oh, count one.
Mr. Brinkley, you're before the court this morning for 8 different counts. Count 2 is home invasion without a firearm. Count 3 is false imprisonment. Count 4 is larceny. Count 5, drug paraphernalia. Count 6, your parole violation. Count 7 is parole violation. And count 8 is a misdemeanor capias. The court does find probable cause as the parties wish to be heard as to bond.
Yes, Your Honor. On count 1 and 2, the state is going to be seeking a $100,000 bond on each count. On 3, a $50,000 bond. Should he post those bonds to be eligible for release? Pretrial release with a GPS monitor, level 1. No contact with the alleged victim, EK. Your Honor, I'm greatly concerned based not only on these allegations, but I would also note, as the court is aware, Mr. Brinkley is on parole for a grand theft. That was a 2017 grand theft where he was sentenced to 25 months state prison as a habitual offender. Another grand theft in 2016 where he received the same sentence as a habitual offender. 08 delivery of cocaine, VOP 6-year state prison. Those are the most significant priors.
In light of the no bond holds on Mr. Brinkley for the parole violation matters, the defense at this time would waive any argument regarding proof evident presumption grade until Mr. Brinkley can appear before his division judge for an Arthur hearing.
And Judge, the only additional information I wish to give you, I understand the state's request as far as their bond amounts, but that's just simply something that Mr. Brinkley cannot afford. Unfortunately, he's financially indigent and he is homeless. So I'd ask you to take that into account as well.
Yeah, and Your Honor, just noting for the record, looking at the booking sheet on count 2 for the home invasion, it states no bond. However, the allegation is home invasion without a firearm or weapon, which would make it a first-degree felony and bond eligible.
Thank you. All right. The court does have great concerns based on the allegations in this case. The court does find probable cause. As to count 1, your bond, sir, is $100,000. Count 2, $100,000. Count 3, $50,000. Count 4, the bond will be $100. Count 5, no bond is required, so will not impose a bond. Your 6 and 7 are your parole violation. Those are no bond holds. And as to count 8, the misdemeanor capias, it's $100. Good luck, sir.
And, Your Honor,
And Mr. Brinkley, no contact with the the alleged victim in this case. What are her initials? You said
EK.
EK.
And Your Honor, as far as the state's request, should he be eligible for release at some point?
Yes, there is, if, if Mr. Brinkley is able to post his bond, he's also going to be on, level 1 supervision. Thank you.
Judge, I'm sorry.
Yes.
Before we get too far, on Scott Clifton, count 1, he had a, it looked like an unnatural act of rules and lascivious act, and I heard you said $1,000.
Didn't he resolve his case?
No,
You'd offer 10 days, he declined.
Okay.
but right, but first you said 1,000, and then the state offered 10. I heard you say 1,000, and then the state offered 10 days. He declined the 10 days, but
The bond is $1,000.
okay.
Arlington Salter.
He's here, present, Judge.
Mr. Salter, you're before the court today for 1 count of possession of cocaine, 2, possession of controlled substance without prescription, 4, driving while license suspended, first offense, and 4, not for magistrate, failing to wear a seatbelt. The court does find probable cause. Does the parties wish to be heard as to the bond of Mr. Salter?
Judge, Mr. Salter advised me that he's going to be reaching out, I believe, to his girlfriend and mom to see, have them post a bond. He believes that they can come up with the bonds for counts 1 and 2 using the services of bondman. So I want to see if the state has an objection just on count 3 and ROR on that offense alone.
That's fine. Elizabeth Friedman for the record on behalf of the state.
Thank you. The court does find probable cause. The bond counts 1 and 2, $1,000 each. And on count 3, the court will ROR, and count 4 is not for magistrate. Good luck, sir. James Antoine Walker.
Bonded, Judge?
Court does find probable cause. Floyd Walker.
He's here, present, Judge.
Mr. Walker, you're before the court for 1 count of selling drugs, 2, possession of more than 10 grams of Schedule 1A, 1B, or J, and 3, possession of drug paraphernalia. The court does find probable cause. The bonds,
Sure.
yes.
And speaking of Mr. Walker, he does not think his mom can afford to post his monetary bond. He lives in Miramar with his mother, and from what he advised me, she works at Wendy's right now. He is looking for work. He's been here his whole entire life. He's 22 years old, Judge. We're asking for Mr. Walker to be released on pretrial release.
What kind of work does Mr. Walker do when he's working?
When was the
What? I didn't hear what he said.
Judge, he says he's going to be looking in the construction area, hopefully at a labor pool, at a construction site, try and get employed in that type of line of work.
When was the last time you were employed?
You are.
Employed, well, I never really looked for a job, but my record, this is my first time in county, so I'm looking for me a job and stuff.
What kind of priors does Mr. Walker have? State?
Okay, sounds good.
He is none, Your Honor.
Bye.
Your Honor, we would ask for not a straight pretrial release, because charge 2 is a first-degree felony. We would be asking, we'd be okay with a reduced bond and some kind of monitoring, but not just an outright release.
What kind of priors does Mr. Walker have? That
He
was,
doesn't, Your Honor.
no priors?
Not in Broward County. Oh, okay. No fires.
Okay, the court does find probable cause. As to count 1, there will be a bond of $1,000. Count 2 will be $2,000, and count 3 will be $100. And if Mr. Walker is able to post his bond, he should also be under pretrial supervision.
Is that standard or would you like?
Standard, thanks.
One moment, Judge.
Yes.
I understand the court's ruling, that, you reduce the bond. Would the court consider then an R1 count 3, the drug paraphernalia, considering he has no priors?
That's fine. Nope. Fernando Mendez Vega.
Come on up, sir, Mr. Mendez Vega.
Morning, sir. You're before the court for 1 count of aggravated battery with a deadly weapon. The court does find probable cause.
Oh,
The parties wish to be heard as to bond.
yes, Your Honor. One moment. Your Honor, based on the level of violence, we'd be asking for a $20,000 bond. He's also currently out on a 2017 possession of cocaine with intent to distribute or sell, possession of cannabis, possession of drug paraphernalia, and a no valid.
Judge, in speaking, Mr. Mendez Vega, he's not going to be able to afford what you're suggesting. He's on disability right now. He gets approximately $700. He rents a room in a house in Hollywood, which is $500. So he just basically lives month to month on that disability. He's 41 years old. He does have a friend that lives in the community. He doesn't know exactly how much a friend can afford. He believes something minimal. So Mr. Mendez is requesting a $2,000 bond, and I understand for that type of offense is a low monetary bond, so we wouldn't have any objection besides the monetary bond. The court imposing standard pretrial release on Mr. Mendez Vega besides the monetary bond, Judge.
The court does find probable cause, and it's a little bit concerning, the circumstances. And so I'm going to impose a bond of $10,000, and if Mr. Mendez Vega is able to post his bond, he'll be on a level 2 supervision. Good luck, sir.
Your Honor, we also be asking with no victim contact.
And no contact with Alberto Cabrera. Is there another victim? That was the only one, right?
Yes, Your Honor.
Okay. 10. Robert James Giddings.
Mr. Giddings is here present, Judge, at main.
Mr. Giddings, good morning. You're before the court on one count of burglary of an unoccupied conveyance unarmed. The court does find probable cause.
Mr. Giddings is currently being supervised by pretrial services. He was placed on pretrial supervision on the 6th of January in case 19187 CF10A. One count of grand theft, two counts of grand theft, one count of dealing in stolen property, and one count of fraud. Based on this court's finding of probable cause, we ask that his pretrial status be revoked on this open case on all 4 counts.
The court will grant a pretrial's request to revoke pretrial on case number 19187 CF10A.
Judge, I'm asking you at this time not to take any action on that based on pretrial's request. From what Mr. Giddings advised me, on this case, he's looking forward to having his day in court. He's unfortunately at this time homeless. He can't afford he can't afford a monetary bond. He was working about 3 months ago at a warehouse, at a computer assembly warehouse, but he's not working there anymore. So right now, financially, he can't come up with anything. We're going to be asking for the court to sign an order allowing us to photograph the injuries that Mr. Giddings sustained, and we're going to be asking that the court release him on pretrial release on this case, Judge.
That's going to be denied. He's on pretrial release on one matter. He doesn't do what he's supposed to do. The bond, I'm gonna revoke the pretrial release on the other case as previously stated, and I'll impose $1,000 bond on this new case. Good luck.
And the revocation is no binding?
Yes.
Thank you. 1,000 on this.
We have the Spanish interpreter, Elmer Rivera. Where was Mr. Rivera again? North Broward?
No, he was here at Maine,
He was
Judge.
at
I believe
Maine?
he was on page 7 of the docket. Yes.
Mr. Rivera, Madam Interpreter, please raise your right hand. Do you swear or affirm to translate from Spanish to English, English to Spanish?
I do.
Can you state your name for the record?
Yes, Your Honor. It's Solange Sands, S-A-E-N-Z.
Okay, Ms. Science. Thank you for being here. Mr. Rivera, you're before the court this morning for 5 counts on a misdemeanor capias.
Señor Rivera, usted está aquí acusado de 5 cargos y uno es orden de arresto por falta de comparecer.
My notes indicate that you should be before your judge tomorrow at 8:30.
Tenemos anotaciones sobre su caso que dice que se va a presentar sobre el juez que está asignado a ese caso mañana a las 8:30 de la mañana.
That's your division judge.
Ese es el juez que está designado para los casos de delito de grado menor.
So for this morning, I'll find probable cause.
Para lo que estamos haciendo hoy, voy a decido que existe motivo fundado.
And I will leave the bonds in place.
Las fianzas que se habían emitido para sus cargos anteriores quedan igual.
And for your information, it's DUI, the count 1 is $7,500.
Para que usted esté enterado, el primer cargo es de DUI, conducir bajo efectos de bebidas alcohólicas o de drogas, y esa fianza es de $7,500.
Counts 2 and 3 is also $7,500.
El cargo 2 y 3 también son de $7,500.
Count 4 is $1,000.
El cargo número 4 es $1,000.
And count 5 is $1,500.
Y el quinto es $1,500.
Good luck, sir.
Buena suerte, señor.
Is there anyone else who's in need of the Spanish interpreter?
¿Alguien más que necesite la ayuda de la intérprete de español?
No one else at Maine, Judge. I don't know if the other facilities.
And North Broward, do we need a Spanish interpreter?
No,
Okay. How about Conti
no, ma'am.
or Paul Ryan? All right, hearing nothing, Ms. Sayens, thank you very much.
Sí, Your Honor.
All
Have a
right,
great
good
day.
luck. You too. Normaine Tyshawn Johnson.
He's here, Maine.
Mr. Johnson, good morning. You're before the court for one count of possession of burglary tools with intent to use, and two, burglary for a dwelling or structure or conveyance armed. The court does find probable cause. Does the parties wish to be heard?
Your Honor, yes. The state is not going to be seeking a no bond hold at this time. However, I am going to be requesting a $20,000 bond on count 2, the armed burglary. It's a punishable by life offense. I would also note, and I spoke to both detectives involved in this case, and what they advised me, based on their investigation, it does not appear that Mr. Johnson has ties to the community here. As you can see in both the booking and the PC affidavit, it shows his address is in Kissimmee.
Mr. Romero?
Judge, the bond that the state is suggesting is something that Mr. Johnson cannot afford. My understanding is working, and he works at a company that sets up different
Foods or decorations for parties.
for parties, in which he makes about $250 per week. He does live in Kissimmee. He lives with his sister and a judge at the apartment that they rent. Their monthly rent is approximately $1,300. His sister does work. She works at Walmart. He's going to be reaching out to his family to help post that bond. But Judge, his funds are limited. What I'm going to be asking, Judge, on count 2, to set a bond of $5,000 on Mr. Johnson's behalf. And I do understand, I believe Mr. Johnson has a clean record. So I'd ask you, if the state can verify, to ask you to take that into account as well.
Your Honor, he has no record. My concerns are solely his lack of ties and also the allegation that fortunately no one was home, but that he broke into a home and while doing so was in possession of a stun gun.
Mr. Johnson, who are you staying with locally?
My friend Mo, he lives close to here.
Okay. All right. As to count 1, the bond is $1,000, and on count 2, your bond is $10,000. Good luck, sir. Kenyatta Ford.
Judge, Mr. Ford is approaching, and he declined to serve as a public defender.
Mr. Ford, good morning. Sir, do you have a private attorney?
Yes, I'm gonna go get one.
I'm sorry?
Yes, so yes, I have one. I have to call him.
You have to call him? So you wish to proceed this morning without an attorney?
If I can resolve it, yes.
Well, you're not going to resolve it here. It's a third-degree felony, so there's no resolving the felony case here.
Okay.
You're asking to resolve the case, and I'm telling you that you cannot resolve your felony case at first appearance. So do you wish to proceed without an attorney?
Yes.
Okay. Well, Mr. Ford, you're before the court for one count of possession of cocaine. The court does find probable cause, and your bond is $1,000. Good luck, sir. Mikhail Alexander Hutchinson.
He's approaching, Judge. He's here at Maine.
Mr. Hutchinson, you're before the court today for one count of burglary of an unoccupied dwelling unarmed, 2, possession of burglary tools with intent to use, and 3, possession of cannabis over 20 grams The court does find probable cause as parties wish to be heard as to bond.
Your Honor, we'd be asking for $20,000 because he has an open case, a 2018 aggravated fleeing and eluding, another aggravated fleeing and eluding. Oh, just one aggravated fleeing and eluding.
Mr. Romero?
Judge, I'm gonna be requesting $2,000 bond on Mr. Hutchinson's behalf on count one, leaving the bonds in place on counts 2 and 3. My understanding, Judge, he's currently looking for work. He advised me that he has 2 interviews already lined up, one at Walmart and one at a warehouse. So right now he's unemployed. He lives in Fort Lauderdale. He's been living at that apartment for about 2 months right now. Judge, he did give me the phone number of his mother. I intend on calling her after court to see if she can help with the monetary bond. But right now, from what he advised me, if the court were inclined to set a $2,000 bond on count 1, along with the bonds that are currently placed on counts 2 and 3, $1,000, so the total request would be a $4,000 bond on his behalf, Judge.
When was the last time Mr. Hutchinson was employed?
Judge, he advised me 2 months ago, and I'm right now going to get the particulars of that. Judge, he advised me that it was 2 months ago at a call center in Boca Raton, for customer service.
The court does find probable cause as to count 1, imposing a bond of $5,000. Count 2 is $1,000 and count 3, $1,000. Good luck, sir. Elise Alexis.
Sure, Alexis is here present, Judge. He gave me the phone number of his family. He believes that his wife is hiring an attorney, and I know my colleague has been trying to contact, no one's answered, so this time, in an abundance of caution, I'm going to be asking you to go ahead and reset this for the afternoon, Judge.
No. If you give me the phone number, I'll call his wife.
I'll give it to you. Oh, Sue's been calling. A 954. Sue's calling you right now.
All right, then I'll recall Mr. Alexis. You can let me know what we're doing. Let's go to Rudy Palau.
He's here present, Judge.
Mr. Palau, you're before the court for possession of alprazolam. The court does find probable cause. What do the parties wish to tell me about Mr. Palau?
Judge, my understanding is I believe Mr. Palau has a clean record. I believe he has a speeding. If the state can verify that, would the court have an objection as far as, or would the court incline to release Mr. Palau ROR on this nonviolent offense?
Well, problem is, Your Honor, he was arrested about 25 days ago in Georgia for possession, purchase, manufacturing, distributing, or sale of marijuana. So it looks like he's got an open felony in Georgia.
And no request at this time, Judge, from the defense.
And the bond is $1,000. Good luck, sir. Derek Jules.
Your Honor, this is Michael Weinstein's case. Let me just check. They may ask us to be reset for this afternoon. Let me just give them a quick call back.
They're asking for it to be reset for the afternoon?
I believe so, but let me just double check that if you could give me 1 second.
Okay. Mr. Jules, just hold on. They're trying to call your attorney. Antoine Absaint?
Mr. Absaint. What to do with Mr. Jules? Move him to what? The 6th?
Is this Antoine Absaint?
Yes, Judge.
Like today.
Sir, you're before the court today for one count of petty theft, third or
You can rescind it
subsequent
this afternoon.
offense, and two is resisting officer without violence.
All right, all right.
I've read the
You gotta
probable
rule
cause, the court does find
probation
probable
violation
cause.
anyway.
Mr. Absain's bond
So, I mean, there's not much I can really do.
on one is $750,
$750 bond on a traffic.
and I will not oppose a bond on two.
And he's got another, looks like another trafficking in heroin.
Judge, Mr. Hobson is asking if the court will be inclined on this felony petty theft to release him on pretrial release. He advised me he's not working, but he lives in Miami, Judge, and he's asking for the court to release him on pretrial release.
Your Honor, the state would be asking that the bond be kept in place because of his 6 prior convictions for petty theft or theft, and the recent other charges.
What was the most recent petty theft?
In 2017, he had a petty theft, a felony petty theft, that resulted in a VOP.
Okay, the bond is $750. Good luck, sir.
Judge, would you be then inclined to reduce it from $750 to $100? So the problem is going to be the collateral, and I would ask you to take into account. I mean, the last time he had a petty theft was in 2017, and
That will be
It's
denied.
outrageous.
That will be denied, Mr. Romero. Good luck. Kent Roger LaFleur.
Judge, I've been informed bonded.
Okay. I find probable cause in absentia. Clifford Frage. Frage. Okay, how about Mr. Koziskowski? Is also bonded? Marcus Nagel?
Judge, if we could put him on brief recall, I believe he's at the restroom. Or he might be coming in right now, Judge. Hold on 1 second. I'm finding, there's someone. He's approaching, Judge.
Okay.
He's approaching.
Mr. Nagel, good morning. You're before the court today for one count of burglary of an unoccupied dwelling unarmed, and the second count is grand theft. The court does find probable cause. Does the parties wish to be heard as to bond on count one?
Your Honor, the state's going to be requesting a $15,000 bond on count one. Mr. Nagel appeared before the court on Monday, and that was on a trespass at the Marriott Hotel. The allegations were in that case that he was seen in the pool area with shaving cream covering his body from head to toe. He's been, staff advised he'd been trespassing that hotel in the past, and contact was made with him while he was standing in the bathroom of the pool area changing clothes. My concern is now this involves breaking into a room at a different hotel, stealing cash from that room. It appears clearly there's issues with Mr. Nagel going to hotels that he has no business going to. He also in 2018 had a possession of methamphetamine. If I could just check one thing. Okay. He pled out the possession of methamphetamine in November of last year to 6 months probation. His probation was terminated upon serving a county jail sentence.
Judge, from what Mr. Nagel advised me, right now, he's not, working, he's currently looking for work. He's gonna be reaching out to friends to try and help post his monetary bond. Judge, we're gonna be asking for a $5,000 bond on his behalf on count one.
All right, the court does find probable cause as to count one. I'm imposing a bond of $7,500. On count two, it's $1,000. Mr. Nagel, this is the Conrad Hotel? Is that what I read? Conrad.
I think it's the name.
Yes, well, it says Conrad in Fort Lauderdale. No return to that hotel, sir, and I don't know how else to tell you not to go back to this hotel. Do not go back to the hotel. Thank you. Preston James Williams. Preston Williams?
He's here present, Judge.
Mr. Williams, good morning. You're before the court for one count of petty theft, second offense, and counts 2 and 3 are felony capias. There are no bond holds and not for magistrate, so the bond for $25 on count 1 will remain. You should be before your felony judge, it looks like tomorrow at 8:30. Good luck, sir. Latavian Damon Laster.
He's here present, Judge.
And Mr. Reedy, when you're ready with the other ones, you can let me know. I believe that you were making a phone call to some.
I did, no one answered.
Okay, all right. Latavian Laster, Mr. Laster, you're before the
He's here
court
present.
for one count of grand theft of a firearm and 2 tampering or fabricating physical evidence. The court does find probable cause. Sir, your bonds are $1,000 each count. Good luck. All right, so, that was Derek Jules that they were asking for a reset.
I'm waiting for a call back from Mr. Weinstein.
All right, well, if he calls back before we're done, otherwise we'll reset to the afternoon. And how about Elise Alexis? We were waiting.
Yes, I called the number I was given for Mr. Alexis's wife, and there was no answer.
Okay. We were calling her in regards to finding out about.
Whether or not she's going to hire an attorney.
Oh, okay. Mr. Alexis, an attempt has been made to call your wife to determine whether or not there will be a hiring of a private attorney. There was no answer at the number, so you need to are you going to proceed with the public defender this morning?
One moment, Judge, I'm speaking to him.
Okay.
One moment. I did explain to him what's going on. We were trying to contact his wife, but unfortunately, no answer. Mr. Alexis then at this point wishes to proceed with the public defender's office, but I'm gonna need a little bit of time to, speak to him, Judge.
Okay. All right, then I'll move on to Ronald Sands. Judge, I'll miss the Sands. Thank you.
We are just waiting on the corrected case from the clerk's office, so we asking if you find probable cause, if you just write in the charge of what it should be. It was a change of charge.
Here's all the paperwork on the change of charges.
Okay.
Your Honor, if I may, the only thing that is missing on the robbery firearm, it's while wearing a mask. It has a mask enhancement included.
So,
On this
let me tell you what I have before me, and then you can tell me how we want to correct it so that everyone is on the same page. I have, robbery with firearm, count 1, it looks like. And then 2 is attempted robbery with firearm. That's what I have that says it's the corrected KPS.
That is correct, Your Honor. The robbery firearm with a mask is a change of charge. It was upfiled from robbery with a firearm. I provided the court with the original findings of Judge Malika. She found proof evident of presumption great on the robbery firearm and ordered Mr. Sands to be held no bond on that count. I'd asked the court to impose the previous findings. The only difference with the charge is it includes the mask enhancement. As you can see in the probable cause affidavit, it does make reference to a mask that Mr. Sands was wearing. The second count, the attempt, is an ad charge, Judge. And basically, it was just ad charge because, as you can see in the PC I attached, it mentions a second victim, but no property was taken from that second victim.
Okay. Okay, so I only have 4 on my paperwork, on the actual PC. So I only have the felony KPS for case number 18-015-018 CF10A. That's what I have on my PC. So so as not to create any confusion, is the 18-015-016 CF10A.
They didn't include the robbery firearm with the mask on the findings.
Okay, so we can write
Will that resolve the issue? Because we've had this before, and then they come back the next day and it's not resolved, so.
I think this should resolve it. If the court were to write in robbery with a firearm while wearing mask,
Is that going to be 5, or what number is that?
number 1, that's the COC. The case is number 4.
Robbery with firearm, robbery.
Robbery armed while wearing a mask.
Okay. All right. On count 4, Judge Malika previously found proof is evident and no bond.
Count
No.
4 is the ad charge.
on one she did.
On 1 she did, okay? And then on 4, I need to set a bond on that one.
Yes, ma'am.
Okay.
And, Your Honor, the state would be requesting a $25,000 bond.
All right. So, Mr. Sands, we have to make sure that the paperwork is right. So, on your account 1, which is a robbery with firearm wearing a mask, there was a no bond hold previously imposed. I'm not going to make any changes as to that. And then on count 4, I'll impose the $25,000 bond. Good luck, sir. 25. Yes. Mr. Linder, you need your paperwork back? Thank you.
Well, that was on all this, that was for about 4 different cases, Judge.
Yes.
Oh,
Oh, not for just his
no, it
case?
wasn't just, no. I just figured I'd give them all to you at once.
Okay, so I have Mr. Sands. All right. So apparently the other 2 are going to, 3 or 4, we have to resolve issues. Are we ready with anyone at man? Richard Green?
Judge, yes, I'm sorry.
That's cool. Yeah, no, it's priority.
Mr. Green is on medical
Yeah,
reset?
and I don't know
Medical reset, North Priority.
if we can, when Mr. Reedy gets, when he's available, if we can inquire, she can see, we filed a battery, he was arrested for aggravated battery on a person 65 years of age or older. We filed as a battery. Judge Carpenter-Toy crossed out the aggravated. She only found PC for what we actually filed. So I don't know if Mr. Reedy would be inclined to maybe waive his appearance to have him avoid having to be brought back down again. Brian? On Richard Green, we filed the offense that Judge Carpenter-Toy found PC for. She crossed off the aggravated and only found PC for battery the victim. It's a medical reset. Would you be inclined to waive? So we just have the bond reset and.
All right, so as to Mr. Green, find probable cause, which was already found, and the bond is $10,000.
I guess next would be.
Do we have the same issue on the next three?
A little bit different on Alex Beltran.
Alex Beltran,
Medical reset, North Priority.
I think we may have to reset him. The reason being, as you can see, he was, originally it was 2 counts of aggravated battery. Judge Malika found PC for 1 count of aggravated battery. We filed a 2nd count of aggravated assault, so it's a lesser offense. So I think that might be, I mean,
all
unless
right, so
Mr.
that's a change. Okay, we have to bring him back. He's on medical reset. Johnny Davis,
Conti, Your Honor.
And this is going to be the same situation on the next 2 cases, Judge. As you can see on the original findings, Judge Malika found proof evident or presumption great for burglary with a battery. We filed it as a burglary of a conveyance with a battery armed. It's still the same underlying offense, burglary with a battery. So I'd ask the court to impose the findings that Judge Malika made. The attempted robbery with a firearm, she found PC for attempt.
I see that.
And that's what we ended up filing, so I would just ask the court to impose the bond that Judge Malika originally said.
All right, so, Mr. Davis, you're before the court today for, it's an adjustment on 2 counts. You were before the magistrate before, and so I'm not going to make any changes as to the bonds on those 2 counts. Good luck, sir.
Okay.
Yes, ma'am,
And 50,000
that's
on
correct.
the robbery.
Right,
But he had pretrial GPS. Are we opposing pretrial GPS?
yes.
And before he comes up on Joshua Kelly, he's a co-defendant, same exact situation, Judge.
He's a co-defendant?
Yes.
Okay.
I don't know if he's a Conti also.
Joshua Kelly?
Yeah, and main judge.
All right. So, Mr. Kelly, you're before the court today. There's adjustment on 2 of the counts, burglary of a conveyance, battery, armed battery, and then robbery, attempted robbery. But those, I'm looking at the previous PC. The judge did write those in, so those are already found. What are the? So I'm not going to make any change as to those counts, as to the bond, whatever the release conditions were. It looks like the burglary, no bond, and then on the attempted, there was $50,000 with pretrial GPS. All right, good luck, sir. All right, what are we doing with, we have 2 more left, Derek Jules and Elise Alexis.
Mr. Elise Alexis, we're ready to proceed, Judge.
All right,
And Judge, we're going to be waiving formal reading of the charges.
okay. Well, Mr. Alexis, you're before the court today for, there are 3 counts before the court. I do find probable cause, and what do the parties wish to be heard as to bond?
Your Honor, I'm going to be requesting on count 1 a $50,000 bond, on count 2 a $75,000 bond, pretrial release with a GPS monitor, an order of no victim contact with JP, an order of no contact with minors, An additional order that Mr. Alexis is not to be in possession of any devices with internet access until further order of the court. And lastly, Your Honor, I'm going to be requesting that Mr. Alexis surrender his passport to the clerk of court prior to his release from custody, and that he not be in possession of or reapply for any type of passport until further order of the court.
Judge, we're gonna be requesting on count one a $5,000 bond and on count two a $5,000 bond, a total of $10,000. My understanding, Judge, he works off and on in landscaping. He's 31 years old, been residing here in South Florida now for about 2 years. He lives in Coral Springs with his wife and 2 kids. Both of his sons attend public school and his wife is working. She is a caretaker, and their monthly rent at that apartment is approximately $1,000 per month. Now, he did advise me he owns property. He owns a Honda Accord of 2002 with over 200,000 miles on it. Judge, he's going to be reaching out to his family to help post his monetary bond. Judge, we don't have any objection as far as at this point, no access to any internet-able devices. But Judge, we're going to be asking the court to consider the 5,000 on one, 5,002, and we're going to be asking Judge to place Mr. Alexis on standard pretrial release. And my understanding, Judge, this is his first arrest ever.
Thank you. Mr. Alexis, the court does have great concerns for the allegations surrounding this arrest. I do find probable cause. As to count one, I'm imposing a bond of $50,000. On count two, $75,000. And count three, the bond is $1,000. Also, if you're able to post your bond, you'll be on a GPS monitor. No contact with the minor, JP. No access to any device to where you can have internet access. And you must surrender your passport if you are able to post your bond, you need to surrender your passport. And no application for a passport until this case is resolved. Good luck, sir.
And Your Honor, we just also requested no contact with minors.
I believe I said that, but if I didn't, no contact with minors.
Judge, as far as that, I'd ask, I did advise the court that he has 2 sons. I'd ask to exclude his children.
I understand that, but my order is no contact with minors. Thank you. Derek Jules.
Mr. Weinstein's office is requesting the case be reset till this afternoon at 1 o'clock, Your Honor.
Okay, then I'll reset this, Jules, for the afternoon. Okay, that's Mr. Jules sitting there. Mr. Jules, you're reset till the afternoon. Your attorney's asking for it to be reset. Okay. All right, that brings us to the end of the morning docket. Is there any? Thank you.
Or if I could just have, I mean, we don't have to stay on, if I could just have a minute to finish this order.
Oh, sure.